Maintenance of train and tracks. Duty to make sure that the vehicle or the means of transportation is in good and safe working condition. Embarking and disembarking passengers. The court said it is a matter of common knowledge and experience about common carriers like trains and buses that before reaching a station or flag's stop, they slow down and the conductor announces the name of the place. Reasonable opportunity to enter or disembark. Persons and properties run over by trains. It is not the duty of the engine driver or engineer to stop the train every time that he sees a person on or near the tracks. If the engine drivers were required to slow down or stop their trains every time they see a pedestrian on or near the track of the railroad, it might, become impossible for them to maintain a reasonable rate. As a result, the general traveling public would be exposed to great inconvenience and delay. Indeed, a person who is walking on the tracks must exercise due care in avoiding his own death or injury. Passengers' baggage. Article 1754 of the NCC states the rules on hand-carried baggage and checked-in baggage. The provisions of Articles 173 to 1753 shall apply to the passenger's baggage which is not in his personal custody or in that of his employee. As to other baggage, the rules in Articles 1998 and 2000 to 2003 concerning the responsibility of hotel keepers shall be applicable. Baggage defined. The term baggage has been defined to include whatever articles a passenger usually takes with him for his own personal use, comfort, and convenience according to the habits or wants of the particular class to which he belongs, either with reference to his immediate necessaries or to the ultimate purpose of his journey. Ltfrb rules. In land transportation, the conditions for the issuance of a certificate of public convenience for public utility vehicles imposed by the Land Transportation Franchising Regulatory Board include the following rules. Every passenger is entitled to a free carriage of 10 kilograms of baggage and shall pay the corresponding freightage for excess weight. Number 2, when the PUV operators units carry both passengers and freight, the freight shall be placed in a separate compartment, except packages or bundles, the size of which will allow placement under the seats without causing inconvenience to and compromising the safety of the other passengers. Number 3, in case of freight is carried on top of public utility buses, it shall not exceed 20 kilos per square meter of roof area, distributed so that it will not endanger the lives of passengers or stability of the bus unit. The PUV operator shall not load animals of any kind except fowls. In the carriage of such fowls and other animals, the inconvenience, comfort, and safety of the passenger shall not in any way be sacrificed. Checked-in baggage. Baggages that are checked in or delivered to the carrier are governed by the rules regarding carriage of goods. Articles 1733, 1734, and 1736 of the NCC were applied to hold the carrier liable. Hand-carried luggage. The rules under Articles 1998, 2000 to 2003 of the NCC on necessary deposit apply. The passenger are duty-bound to give notice to the common carrier or the carrier's employees of the effects brought by passenger and 2, to take the precautions which the common carrier of their substitutes advise relative to the care and vigilance of their effect. Obligations of the passenger and shipper. Duty to exercise due diligence. The shipper or passenger is bound by his contractual obligation. They are bound to exercise due diligence in avoiding damage or injury. Negligence of shipper or passenger. The shipper is obliged to exercise due diligence in avoiding damage to the goods that are being shipped or injury to his person. In Spouses Fabre versus CA, it was held that the carrier cannot impute negligence of its own employee, like its driver, to the person or entity that hired the carrier. Duties of the shipper. Duty to disclose. Due diligence include the duty to disclose information relating to the cargo. Proper information will help the carrier exercise proper care and caution in relation and not only to the subject cargo, but also to the cargo of other shippers and passengers. The shipper must also make the proper markings on the cargoes. Damage caused by cargoes. The duty to disclose the nature of the cargo is important in order that the carrier can exercise due diligence in preventing damage to the cargoes to be transported. Thus, the shipper may be held liable for any damage that may have been caused solely by the dangerous nature of the cargoes or the defect in the packaging of the cargoes. Duty to pay freight. Common carriers are subject to heavy regulation with respect to rates that they are charging the public. In regulating the rates charged by the public utilities, the state protects the public against arbitrary and excessive rates while maintaining the efficiency and quality of service rendered. Who will pay the freight? The shipper may pay the necessary freight before or at the time he delivers the goods to the carrier for shipment. The parties may also stipulate that the consignee will pay the freight at the point of destination. Nevertheless, the consignor with whom the contract of carriage is made is primarily liable for the payment of the freight charges, whether or not he is the owner of the goods. Passengers are contractually bound to pay the fare within such time as prescribed by regulations or by the carrier. And according to the Code of Commerce, provided that in the absence of any agreement, the consignee who is supposed to pay must do so within 24 hours from the time of delivery. Carriage of passengers by sea. The tickets are purchased in advance from ticket outlets or booking offices that are required to be set up in every part of the vessel. Carriers are not supposed to allow passengers without tickets. Carrier's lien. If the consignor or the consignee fail to pay the consideration for the transportation of the goods, the carrier may exercise his lien in accordance with Article 375 of the Code of Commerce, but the 8-day limitation is modified to 30 days. Article 375. The goods transported shall be especially bound to answer for the cost of transportation and for the expenses and fees incurred for them during their conveyance and until the moment of their delivery. This special right shall prescribe 8 days after the delivery has been made, and once prescribed, the carrier shall have no other action than that corresponding to him as an ordinary creditor. The shipper must make sure that the goods are delivered to the carrier on the date, time, and place agreed upon. The consignee must likewise timely obtain delivery from the carrier. Demurrage is the compensation provided for in the contract of affreightment for the detention of the vessel beyond the time agreed on for loading and unloading. Liability for demurrage exists only when expressly stipulated in the contract. Last days, the period within which the cargoes are to be loaded and unloaded. Duty to secure permits. The passengers or shipper may also be required to secure the necessary permits for the transportation of certain goods. Shipper's loan and count. Defenses in carriage of goods. Article 1734. No other defense may be raised, exclusive or close list. Flood, storm, earthquake, lightning, or other natural disaster or calamity. Act of the public enemy in war, whether international or civil. Act or omission of the shipper or owner of the goods. The character of the goods or the effects in the packing or in the containers. Order or act of competent public authority. Exercise of extraordinary diligence. Fortuitous event. To be a valid defense must be established to be the proximate cause of the loss. Note, since common carrier is presumed to be negligent, it has been observed that the doctrine of proximate cause is inapplicable to a contract of carriage. The injured passenger or owner of goods need not prove causation to establish his case. The absence of causal connection is only a matter of defense. Requisites for fortuitous event. 1. The cause of the unforeseen and the unexpected occurrence or of the failure of the debtor to comply with his obligation must be independent of the human will. 2. It must be impossible to foresee the event which constitutes the caso fortuito or if it can be foreseen, it must be impossible to avoid. 3. The occurrence must be such as to render it impossible for the debtor to fulfill his obligation in a normal manner. Number 4. The obligor, debtor, must be free from any participation in or the aggravation of the injury resulting to the creditor. Note, in order for the common carrier to be exempted from responsibility, the natural disaster must have been the proximate and only cause of the loss. However, the common carrier must exercise due diligence to prevent or minimize loss before, during, and after the occurrence of flood, storm, or other natural disaster in order that the common carrier may be exempted from liability for the loss, destruction, or deterioration of the goods. Fire is not considered as a natural calamity or disaster. Fire caused by lightning, a natural calamity. Hijacking, it does not fall under the category of exempting causes. The common carrier is presumed to be at fault or to have acted negligently unless there is a proof of ordinary diligence on its part. Mechanical defects. Damage or injury resulting from mechanical defects is not a damage or injury that was caused by a fortuitous event. Carrier is liable to its passengers for damages caused by mechanical defects of the conveyance, breakage of a faulty drag link spring, fractures of the vehicle right steering knuckle, defective brakes. One of the reasons why carrier is made liable despite the presence of mechanical defect is the absence of privity between the passenger and the manufacturer. Gentile versus Fontanar, tire blowouts, was not considered as fortuitous event. Although it was alleged that the tires were in good condition, no evidence was presented to show that the evidence were due to adverse road condition. The carrier must prove all angles. The explosion could have been caused by too much air pressure injected into the tires and the fact that the jeepney was overloaded and speeding at the time of the accident. Other invalid defense: damage to cargo due to explosion of another cargo, not attributable to peril of the seas or accidents of navigation. Other invalid defenses: damage to cargo due to explosion of another cargo, not attributable to peril of the sea or accidents of navigation. Damage by worms and rats resulting to damage to cargoes can't be cited as an excuse by the carrier. Damage by water through a port which had been left open or insufficiently fastened on sailing. 4. Carrier cannot escape liabilities to third persons if damage was caused by barratry, where the master or crew of the ship committed unlawful acts contrary to their duties, includes theft and fraudulently running the ship ashore. Cases. Problem: a carrier bus on its way to its destination encountered an engine failure. Thus, it has to be repaired for 2 days. And while in the repair shop, a typhoon came, resulting to the spoilage of cargoes. What's the answer? A typhoon, although a natural disaster, is not a valid defense if it is shown that it was not the proximate or the only cause of the loss, especially when the facts indicate that the typhoon was foreseeable and could have been detected through the exercise of reasonable care. Cargoes should have been secured while the bus was being repaired for 2 days. Number 2, a passenger told the driver that he has valuable items in his bag which was placed under his feet, and he asked the driver, to which he is seated near, to watch for the bag while he is asleep. There have been incidents of throwing a stone at passing vehicles in the North Expressway while the bus was traversing the superhighway. A stone hurled from the overpass and hit the passenger, resulting to injuries. Can the passenger hold the bus liable for damages? The answer is yes. The incident was foreseeable due to the prior incidents of stone hurling. The bus should have exercised utmost diligence and employed adequate precautionary measures to secure safety of passengers since the incident was foreseeable. However, if the stone throwing was entirely unforeseeable and the carrier exercised the utmost diligence, then the bus can't be held liable. Nonetheless, the burden of proof is on the carrier to prove such exercise of diligence. It is up to the carrier to overthrow the presumption of negligence. If the passenger decides to file a case, all the passenger has to do is to prove that she was a passenger of the bus and that she suffered injuries while on board the bus. Supposing that there were armed men who staged a holdup while the bus was speeding along the highway, one of them stole the passenger's bag and wallet while pointing a gun at him. Is the bus liable? The answer is no. Hand-carried luggages are governed by necessary deposit. Besides, theft with use of arms or through irresistible force is a force majeure which exempts carriers from liability. Number 3. Hijacking cannot exculpate the carrier from liability if it is shown that the employees of the carrier were not overwhelmed by the hijackers and that there was no showing of irresistible force. Since there were 4 employers, while there were only 2 hijackers and only one of them was armed with bladed weapon. On the other hand, a hijacking by 3 armed men is an event which is considered to be beyond the control of the carrier. Thus, the carrier may be adjudged from liability if it can be proven that the hijacking was unforeseeable. Going back to force majeure, in general, has also been invoked as an exempting cause based on Articles 1174, which states that no person shall be responsible for a fortuitous event which could not be foreseen, or which, though foreseen, was inevitable. A fortuitous event has the following characteristics. 1. The cause of the unforeseen and unexpected occurrence, or the failure of the debtor to comply with his obligations, must be independent of human will. 2. It must be impossible to foresee the event, which constitute the casu fortuito, or if it can be foreseen, it must be impossible to avoid. The occurrence must be such as to render it impossible for the debtor to fulfill his obligation in a normal manner, and D, or 4th, the obligor must be free from any participation in the aggravation of the injury resulting to the creditor. There must be an entire exclusion of human agency from the cause of injury or loss. Moreover, a common carrier may not be absolved from liability in case of force majeure or fortuitous event alone. The common carrier must still prove that he was not negligent in causing the death or injury resulting from an accident. Loss of a ship and of its cargo in a wreck due to accident or force majeure must, as a general rule, fall upon the respective owners, except in cases where the wrecking or stranding of the vessel occurred through the malice, carelessness, or lack of skill of the part of the captain, or because the vessel put to sea is insufficiently repaired and prepared. In order that the exemption due to force majeure would apply, the carrier must prove that the loss or destruction of the merchandise was due to accident and force majeure and not to fraud, fault, or negligence on the part of the captain or owner of the ship. Contributory negligence. The liability of the common carrier shall be equitably reduced when the loss, destruction, or deterioration of the goods A. The negligence of the common carrier was the proximate cause thereof, and B. The shipper or owner merely contributed to such loss, destruction, or deterioration. Duration of extraordinary responsibility of goods. Instances when carrier has responsibility to exercise extraordinary diligence. From the time the goods are unconditionally placed in the possession of and received by the carrier or its authorized agent, until the same are delivered actually and constructively by the carrier to the consignee or to the person who has the right to receive them. When goods are temporarily unloaded or stored in transit, unless the shipper or owner has made use of the right of stoppage in transitu. During storage in a warehouse of the carrier at the place of destination, until consignee has been advised of the arrival of the goods and has had reasonable opportunity to remove or dispose them. In dealing with the contract of common carriage of passengers, for a purpose of accuracy, there are 2 aspects of the same, namely, contract to carry at some future time, which contract is consensual, and is necessarily perfected by mere consent, and 2. Contract of carriage or of common carriage, which should be considered as a real contract, for not until the carrier is actually used can the carrier be said to have already assumed the obligation of the carrier. Note, the distinction is important in determining when the common carrier is required to exercise extraordinary responsibility. The birth of the contract is not necessarily the birth of the duty to exercise extraordinary responsibility. Under Article 1736, delivery means unconditionally placing the goods in the possession of the carrier and the carrier receiving them for transportation. Thus, if the common carrier received the goods not for transportation but only for safekeeping, then the duty of extraordinary diligence has not yet started. Unconditionally placing the goods in the possession of the carrier means the shipper cannot get them back from the common carrier at will. The liability of the carrier as common carrier begins with the actual delivery of the goods for transportation and not merely with the formal execution of a receipt or bill of lading. The issuance of a bill of lading is not necessary to complete delivery and acceptance, even where it is provided by statute and that liability commences with the issuance of the bill of lading. Actually, delivery and acceptance are sufficient to bind the carrier. That is Campagna Maritima versus Insurance Company, GRL 18965. Actual or constructive delivery. The extraordinary responsibility of the common carrier ends when, subject to Article 1738, the goods are delivered actually or constructively by the carrier to 1. The consignee, or 2. The person who has the right to receive them, such as agent, brokers, and the like. We are actually repeating this. Stipulation for limitation of liability. There are 2 possible stipulations limiting the liability of the common carrier. Stipulation limiting the common carrier's liability as to the diligence required, and stipulation limiting the common carrier's liability as to the amount of liability. An agreement limiting the common carrier's liability for delay on account of a strike or riot is also valid. Limitation of liability to fixed amount. A stipulation that the common carrier's liability is limited to the value of the goods appearing in the bill of lading unless the shipper or owner declares a greater value is binding. A contract fixing the sum that may be recovered by the owner or shipper for the loss, destruction, or deterioration of the goods is valid if it is reasonable and just under the circumstances and it has been fairly and freely agreed upon. While the passenger may not have signed the plane ticket, he is nevertheless bound by the provisions thereof. Such provisions have been held to be part of the contract of carriage and valid and binding upon the passenger regardless of the latter's lack of knowledge or assent to the regulation. It is what is known as the Contract of Adhesion, wherein one party imposes a ready-made form of contract on the other. The one who adheres to the contract is in reality free to reject it entirely. A contract limiting liability upon an agreed valuation does not offend against the policy of the law forbidding one from contracting against his own negligence. However, the fact that the conditions are printed at the back of the ticket stub in letters too small that they are hard to read would not warrant the presumption that the shipper was aware of those conditions such that he had fairly and freely agreed to those conditions. Factors affecting agreement. The effect of these stipulation is subject to the following provisions. An agreement limiting the common carrier's liability may be annulled by the shipper or owner if the common carrier refused to carry the goods unless the former agreed to such stipulation. Number 2. If the common carrier, without just cause, delays the transportation of the goods or changes the stipulated or usual route, the contract limiting the common carrier's liability cannot be availed of in case of the loss, destruction, or deterioration of the goods. Article 1747. The limitation may be availed of if the delay or change of route was due to a just cause. 3. The fact that the common carrier has no competitor along the line or route or a part thereof to which the contract refers shall be taken into consideration in the question of whether or not a stipulation limiting the common carrier's liability is reasonable, just and in consonance with public policy. Article 1751. Fourth, even when there is an agreement limiting the liability of the common carrier in the vigilance over the goods, the common carrier is disputably presumed to have been negligent in case of their loss, destruction, or deterioration. Article 1752. A stipulation that the common carrier's liability is limited to the value of the goods appearing in the bill of lading unless the shipper owner declares a greater value is binding. Article 1749. Baggage are things that a passenger will bring with him, consistent with a temporary absence from where he lives. Passenger's baggage must have a direct relationship with the passenger who is traveling. For instance, a balikbayan box or suitcase is passenger's baggage. However, 10,000 cans of corned beef is not considered a passenger baggage. They are considered as goods. They are not part of the contract of carriage of passenger. A separate contract of carriage or bill of lading must be entered into in order to transport them. These goods will then be transported whether or not a person is physically traveling with them. There are two kinds of passenger's baggage, which are governed differently. One, passenger baggage in the custody of the passenger or carry-on luggage, and B, passenger baggage not in the custody of the passenger or checked-in luggage. The liability is greater for baggage that is in the custody of the carrier or checked-in baggage as compared to those in the possession of the passenger. Checked-in baggage, the provision of Articles 1733, 1753, or 1733 to 1753 shall apply to passenger's baggage which is not in his personal custody or in that of his employee. As to baggage other than checked-in baggage, they are governed by Articles 1998 and 2000 to 2003 concerning the responsibility of hotel keepers. Article 1754. Article 1998 as applied by analogy, the baggage of passengers in their personal custody or in that of their employees while being transported are regarded as necessary deposits. The common carriers are responsible as depositaries, provided that 1. Notice was given to them or to their employees of the effects brought by the passengers, and 2. The passengers take the precautions which the common carrier advised relative to the care and vigilance of their baggage. In case of loss or injury of the baggage of passengers in their personal custody or in that of their employees while being transported, the carrier is liable if the loss or injury is caused by his servants, his employees, strangers, a thief, or robber done without the use of arms or irresistible force. The carrier is not liable if loss or injury is caused by force majeure, theft, or robbery with the use of arms or resistible force, the acts of the passenger, his family, servants, or visitors, the character of the baggage. The following provisions also figure in determining the liability of the common carrier. The fact that passengers are constrained to rely on the vigilance of the common carrier shall be considered in determining the degree of care required of him. The common carrier cannot free himself from responsibility by posting notices to the effect that he is not liable for the articles brought by the passenger. Any stipulation whereby the responsibility of the common carrier is set forth in Articles 1998 to 2001 is supposed to, or the minutes shall be void. In the Philippine law, the liability of the common carrier with respect to the safety of passengers in general are as follows. A common carrier is bound to carry the passenger safely, as far as human care and foresight can provide, using the utmost diligence of a very cautious person, with a due regard for all the circumstances. In case of death of or injuries to passengers, common carriers are presumed to have been at fault or to have acted negligently, unless they prove that they observe extraordinary diligence. Note, it is not enough that the accident was caused by force majeure. The common carrier must still prove that it was not negligent in causing the injuries resulting from such accident. Bachelor Express illustrates that force majeure is not in itself a defense. The exercise of the diligence required by law is the defense. Void stipulations, general law. The responsibility of a common carrier for the safety of passengers cannot be dispensed with or lessened by stipulation by the posting of notices, by statements on stickers, or otherwise. Article 1757. Exception: when a passenger is carried gratuitously, a stipulation limiting the common carrier's liability for negligence is valid. Exception to the exception: even when a passenger is carried gratuitously, a stipulation limiting the common carrier's liability for willful acts or gross negligence is invalid. That's Article 1758. The reduction of fare does not justify any limitation of the common carrier's liability. Duration of liability, as in the contract of carriage of goods. The perfection of the contract of carriage of passengers does not necessarily coincide with the commencement of the duty of extraordinary diligence. It may occur at the same time or later. Based on jurisprudence, the duty that the carrier of passengers owes to its patrons extend to persons boarding the car as well as those alighting therefrom. This is also reflected in Article 17 of Warsaw Convention, which applies to international air carriage. It provides that the liability of a common carrier for injury to the passenger lasts from embarkation to disembarkation, including the period when the passenger is on board the aircraft. In maritime commerce, Article 698 Code of Commerce relates to the period of the voyage. In case a voyage already begun should be interrupted, the passenger shall be obliged to pay the fare in proportion to the distance covered and have the following reliefs: cause of interruption, an accident, cause of force majeure, what is the relief? Without right to recover for losses and damages. If the cause of interruption is by the captain exclusively, the relief is the right to indemnity. Another is caused by the disability of the vessel, and a passenger should agree to await the repairs. He may not be required to pay any increased price of passage, but if he agreed to await the repairs, his living expenses during the stay shall be for his own account. In case of delay in the departure of the vessel, the passenger have the right to remain on board. If the delay is not due to fortuitous event or force majeure, with the right to be furnished with food for the account of the vessel. If the delay should exceed 10 days, passengers requesting the same shall be entitled to the return of the fare, and if it's due exclusively to the fault of the captain or ship agent, they may also demand indemnity for losses and damages. Extent of liability for damages. Damages recoverable from common carriers, both in cases of carriage of passengers and goods, shall be awarded in accordance with Title 18 concerning damages. Article 2206 on liability in case of death for loss of earning capacity, support, and moral damages for mental anguish shall also apply to the death of a passenger caused by the breach of contract by a common carrier. Thus, the damages recoverable are actual or compensatory damages, moral damages, exemplary damages, nominal, temporary, and liquidated damages, and attorney's fee. Actual or compensatory damages refer to adequate compensation for such pecuniary loss suffered as duly proved. Article 2199. Under Article 2201, the liability for damages include, in case the common carrier acted in good faith, the natural and probable consequence of the breach of the obligation, and those which the parties have foreseen or could have reasonably foreseen at the time the obligation was constituted. In case of fraud, bad faith, malice, or wanton attitude, all damages which may be reasonably attributed to the non-performance of the obligation. In case of death, actual damage also include loss of earning capacity, unless the deceased had no earning capacity at the time of death, and B, support for a period not exceeding 5 years. Article 2206. In the absence of a showing that common carrier's attention was called to the special circumstances requiring prompt delivery of a passenger's luggage, the common carrier cannot be held liable for the cancellation of passengers' contracts, for exhibition of films, as it could not have foreseen such an eventuality when it accepted the luggage for transit. Moral damages. though incapable of pecuniary computation, if they are the proximate result of the common carrier's wrongful act or omission, may be recovered. In cases of breach of contract of carriage, moral damages may be recovered, where 1. The common carrier acted fraudulently, 2. The common carrier acted in bad faith, and 3. That of a passenger resulted even in the absence of bad faith or fraud. Bad faith contemplates a state of mind affirmatively operating with furtive design or with some motive of self-interest or will or for ulterior purposes. When it comes to contracts of common carriage, inattention and lack of care on the part of the carrier resulting in the failure of the passenger to be accommodated in the class contracted for amounts to bad faith or fraud, which entitles the passenger to the award of moral damages in accordance with Article 2220. Willful and deliberate overbooking on the part of the airline carrier constitutes bad faith. Under Section 3, Economic Regulation Number 7 of the Civil Aeronautics Board, overbooking which does not exceed 10% is not considered as deliberate and therefore it does not amount to bad faith. United Airlines versus CA. Exemplary damages in a contract of carriage. Exemplary damages may be awarded if the common carrier acted in wanton, fraudulent, reckless, oppressive, or malevolent manner. Exemplary damages serve as an instrument to serve the ends of law and public policy by reshaping socially deleterious behaviors, specifically in the case to compel the common carrier to control their employees, to tame their reckless instincts, and to force them to take adequate care of human beings and their property. Nominal, tempered, and liquidated damages. These are adjudicated in order that a right of the plaintiff which has been violated by the defendant may be vindicated or recognized, not for the purpose of indemnifying the plaintiff for any loss suffered by him. It may be awarded in case of breach of contract of carriage and in every case where any property right has been invaded. A violation of the passenger's right to be treated with courtesy in accordance with the degree of diligence required by law to be exercised by every common carrier entitles the passenger to nominal damages. Temperate or moderate damages, which are more than nominal but less than compensatory damages, may be recovered when some pecuniary loss has been suffered but its amount cannot, from the nature of the case, be proved in certainty. In the case of Tranco versus Parras, the Supreme Court upheld the award of temporary damages by the CA. Parras failed to show receipts of at least 2 surgeries as well as rehabilitative therapy. Nonetheless, the CA was convinced that Parras should not suffer from the lack of definite proof of his actual expenses for the surgeries and rehabilitative therapy. As the records indicated, Parras was first rushed for emergency treatment to the San Pablo Medical Center in San Pablo City, Laguna, and was later brought to the National Orthopedic Hospital in Quezon City, where he was diagnosed to have suffered a dislocated hip, fracture of the fibula on the right leg, fracture of the small bone of the right leg, and closed fracture on the tibial plateau of the left leg. He underwent surgeries on March 4, 1987 and April 15, 1987 to repair the fractures. Thus, the CA awarded to him temporary damages of $50,000 in the absence of definite proof of his actual expenses towards the end. Liquidated damages are those damages agreed upon by the parties to a contract to be paid in case of breach thereof. And of course, attorney's fees. Under Article 2208, as applicable to a contract of carriage, attorney's fees and expenses of litigation may be recovered in the following cases: when exemplary damages are awarded, when the common carrier's act or omission has compelled the plaintiff to litigate with third persons as to incur expenses to protect his interests, where the common carrier acted in gross and evident bad faith in refusing to satisfy the plaintiff's valid, just, and demandable claim. In any other case where the court deems it just and equitable, the attorney's fees and expenses of litigation should be recovered. Bill of lading. It is a written acknowledgement signed by the master of a vessel or other authorized agent of the carrier that he has received the described goods from the shipper to be transported on the express terms to the described place of destination and to be delivered there to the designated consignee or parties. It is not, however, indispensable for the creation of a contract of carriage. In the absence of a bill of lading, disputes shall be determined by the legal proof which the parties may present in support of their respective claims, according to the general provisions established in the Code of Commerce for commercial contracts. The bill of lading becomes effective usually upon its delivery to and acceptance by the shipper. In the absence of fraud, concealment, or improper conduct, it is presumed that the stipulations of the bill of lading are known to the shipper, and he is generally bound by his acceptance whether he reads the bill or not. The threefold character: receipt as to the quantity and description of the goods shipped. Second, contract to transport and deliver the goods to the consignee or other person therein designated on the terms specified in such instrument. And three, document of title, which makes it a symbol of the goods. The bill of lading constitutes the legal evidence of the contract of transportation, and all disputes between the parties regarding the execution and performance of the contract shall be decided by the contents of the bill of lading issued by the carrier. The law admits no exceptions other than the falsity and material error in its drafting. Bill of lading is covered by the parole evidence rule, in which the terms of the contract are rendered conclusive upon the parties and evidence aliunde is not admissible to vary or contradict a complete and enforceable agreement embodied in a document, subject to well-defined exceptions. Period for filing claim, Article 366 of the Code of Commerce. It's within 24 hours if the indication of the damage cannot be ascertained from the exterior of the package, or at the time of receipt if the indication damage can be so ascertained. Period for filing actions, overland transportation and coast-wise shipping. The general rule under the Civil Code on extrinsic prescription apply. Thus, action for damages must be filed in court within 6 years if a bill of lading was not issued, and within 10 years if a bill of lading was issued. Article 1146 of the NCC. Now, under Code of Commerce, primarily governs domestic transport, but nothing stops parties from stipulating that COGSA applies in their contract. COGSA applicable law for all contracts for carriage of goods by sea to Philippine ports in foreign trade. File claim for apparent loss upon receipt. Under the Code of Commerce, file claim within 24 hours from delivery if damage or loss is not apparent. Under COGSA, file claim within 3 days from delivery if damage or loss is not apparent. Under Code of Commerce, filing of the claim is mandatory, condition precedent for filing an action for damages. Under COGSA, filing of the claim is not mandatory. Under the Code of Commerce, prescriptive period to the filing of action is 10 years from breach if bill of lading or written receipt contract is issued, and 6 years from breach if only through oral contract. Under COGSA, prescriptive period to file an action is 1 year from discharge of goods or date when they should have been delivered, and 1 year period may be extended by stipulation. False declaration of contents. If the carrier has a well-founded suspicion of falsity in the declaration of the contents of the package, the carrier may examine it. If the declaration should be correct, examination and repacking expenses shall be defrayed by the carrier, and in the contrary, by the shipper. Article 357. Air transportation, air commerce or commercial air transport operations, scheduled or unscheduled air transport services for pay or hire. The navigation of aircraft in furtherance of a business. The navigation of aircraft from one place to another for operation in the conduct of a business, or an aircraft operation involving the transport of passengers, cargo, or mail for remuneration or hire. Domestic air commerce within the limits of Philippine territory. Domestic air transportation within the limits of the Philippine territory. Foreign air transport, air transportation between the Philippines and any place outside it or wholly outside the Philippines. International commercial air transport, carriage by aircraft of persons or property for remuneration or hire, or the carriage of mail between any two or more countries. Persons involved in air transportation. Persons and entities involved in air transportation that are regulated by CAAP principally include the air carrier or operator. Air operators may either be a Philippine air carrier or foreign air carrier. Air carrier or operator refers to a person who undertakes, whether directly or indirectly or by a lease or any other arrangement, to engage in air transportation services or air commerce. The term may likewise refer to either a Philippine air carrier or a foreign air carrier as indicated by the context. Philippine air carrier means an air carrier who is a citizen of the Philippines. Foreign air carrier or foreign air operator means an operator not being a Philippine air operator which undertakes, whether directly or indirectly or by lease or any other arrangement, to engage in commercial air transport operations within borders or airspace of the Philippines, whether on a scheduled or chartered basis. Airman refers to an individual who engages as a person in command or as pilot, mechanic, aeronautical engineer, flight radio operator, or member of the crew in the navigation of aircraft while underway, and any individual who is directly in charge of inspection, maintenance, overhauling, or repair of aircraft engine, propellers, or appliances, and individual who serve in the capacity of aircraft dispatcher or air traffic control operator. CAB regulates persons and entities that are involved in the economic aspects of air transportations and entities such as general sales agent, which is a person who, pursuant to an authority from an airline, by itself or through an agent, sells or offers for sale any air transportation or negotiates for or holds himself by solicitation, advertisement, or otherwise as one who sells, provides, furnishes, contracts, or arranges for such air transportation. Cargo sales agent means any person who does not directly operate an aircraft for the purpose of engaging in air transportation or air commerce, and who, as principal or agent, sells or offers for sale any air transportation of cargo or negotiate for or hold himself out solicitation, advertisement, or otherwise as one who provides, sells, furnishes, contracts, or arranges for such air transportation of cargo. Air freight forwarders means any indirect air carrier which, in the ordinary and unusual course of its undertaking, assembles and consolidates or provides for assembling and consolidating such property, or performs or provides for the performance of break, bulking, and distributing operations with respect to consolidated shipments, and is responsible for the transportation of property from the point of receipt to point of destination, and utilizes for the whole or any part of such transportation the services of a direct air carrier. Off-line carrier means, for purposes of the regulation, any foreign air carrier not certificated by the board but who maintains office or who has designated or appointed agents or employees in the Philippines, who sells or offers for sale any air transportation in behalf of said foreign air carrier and or others, or negotiate for or holds itself out by solicitation, advertisement, or otherwise sells, provides, furnishes, contracts, or arranges for such transportation. Air taxi operator means an air carrier utilizing small aircraft for chartered trip and or individual service transportation within the territory of the Republic of the Philippines with proper certification or permit from the board. Charter of aircraft. Charter flight or charter trip means air transportation performed by an air carrier where the entire capacity of one or more aircraft or less than the entire capacity of an aircraft has been engaged for the movement of persons and their personal baggage or for the movement of property on a time, mileage, or trip basis by a person for his own use, including a direct air carrier when such aircraft is engaged solely for the transportation of company personnel or commercial traffic in cases of emergency. Two, by a representative or representatives acting jointly of a group for the use of such group, provided no such representative is professionally engaged in the formation of groups for transportation or in the solicitation of sale of transportation services. Or three, by an air freight forwarder holding a currently effective permit. Pro rata charter means a charter the cost of which is divided among the passengers transported. Single entity charter means a charter the cost of which is borne by the charterer and not by individual passengers directly or indirectly. Mixed charter means a charter the cost of which is borne or pursuant to contract may be borne partly by the charter participants and partly by the charterer. The air traffic rights that may be agreed in the air services agreement upon are referred to as the freedom of the air, the right or privilege in respect of scheduled international air services, first freedom of the air, first freedom right, granted by one state to another state or states to fly across its territory without landing. Second freedom of the air or second freedom right is granted by one state to another state or states to land in its territory for non-traffic purposes. Third freedom of the air or third freedom right is granted by one state to another state to put down in the territory of the first state traffic coming from the home state of the carrier. Fourth freedom of the air or fourth freedom right is granted by one state to another to take on in the territory of the first state traffic destined for the home state of the carrier. And the fifth freedom of the air is granted by one state to another state to put down and to take on in the territory of the first state traffic coming from or destined to a third state. And the sixth freedom of air is the right or privilege of transporting by the home state of the carrier traffic moving between two other states. Seventh freedom of the air, granted by one state to another, of transporting traffic between the territory of the granting state and any third state with no requirements to include on such operation any point in the territory of the recipient state. The eighth freedom of the air is the right or privilege of transporting cabotage traffic between two points in the territory of the granting state on a service which originates or terminates in the home country of the foreign carrier or outside the territory of the granting state. Ninth freedom of the air, or the ninth freedom right, is the right or privilege of transporting cabotage traffic of the granting state on a service performed entirely within the territory of the granting state. Note, only the first five freedoms have been officially recognized by international law. Treaty. There is a breach of contract of carriage when an airline company bumped off a passenger with confirmed reservation or downgraded the passenger's seat accommodation from one class to a lower class. There is also a breach of contract of carriage if an airline company upgraded the seat accommodation of a passenger. Delay and diversion of flight. Airline passengers must take such risks incident to the mode of travel. Adverse weather conditions or extreme climatic changes are some of the perils involved in air travel, the consequences of which the passenger must assume or expect. The fact that the flight was canceled due to fortuitous event does not mean that the carrier's duty already ended. The carrier is still obligated to make the necessary arrangement to transport the passenger on the first available flight. Japan Airlines or Court of Appeals. Delay or diversion of flight due to fortuitous event does not terminate the contract of carriage. The carrier is still duty-bound to safeguard the comfort, convenience, and safety of its stranded passengers. Singapore Airlines versus Fernandes. Rude treatment. The carrier may be held liable for the rude and discourteous treatment of its passengers not only by the crew inside the vessel, but also the staff in the airport and in the branch offices of the carrier. Northwest Airlines versus Katapang. Cancellation due to engine malfunction. When, as a result of engine malfunction, a commercial airline is unable to ferry its passengers on the original contracted route, it still has the duty of fulfilling its responsibility of carrying them to their contracted destination on the most convenient route possible. Civilana versus Northwest Airlines. Denied boarding passengers. General rule: the air carrier is duty-bound to accept and board a passenger with confirmed tickets if the passenger presents himself on time in the airline counter in the airport. The passenger has every right to expect that he be transported on that flight and on that date. Otherwise, the carrier will be liable for breach of contract of carriage. The burden of proving that the passenger is a no-show passenger rests with the carrier. An operator may deny transportation if a passenger refuses to comply with the instructions regarding exit seating restriction or has handicap that can be physically accommodated only by an exit row seat. Bill of Rights for Air Passenger. DTOC DTI Joint Administrative Order Number 1 states in its perambulatory clause that an air carrier ticket constitute a contract of carriage between an air carrier and a passenger, whereby the air carrier, for consideration, obligates itself to transport a passenger by air safely, efficiently, and conveniently along a stipulated route at a given date and time, subject to certain conditions and restrictions. Such a contract of carriage creates an asymmetrical relationship between an air carrier and a passenger. Right to be provided with accurate information before purchase. 1. Right to full, fair, and clear disclosure of the service offered and all the terms and conditions of the contract of carriage. B. Right to clear and non-misleading advertisements of and important reminders regarding fares. C. Right against misleading and fraudulent sales promotion practices. Right to receive the full value of the services purchased. Letter E. Right to transportation and baggage conveyance. Right to be processed for check-in. Right to sufficient processing time. Right to board aircraft for the purpose of flight. Right to compensation. Right to compensation and amenities in case of cancellation of flight. Right to compensation and amenities in case of flight delay, and right to compensation for delayed, loss, and damaged baggage. Right to compensation in case of death or bodily injury of a passenger. Right to immediate payment of compensation. Applicable law. RA 6235. It shall be unlawful to compel a change in the course or destination of an aircraft of Philippine registry, or to seize or usurp the control while it is in flight. It shall likewise be unlawful to an aircraft of foreign registry to land in Philippine territory while in the Philippines. When is an aircraft considered in flight? From the moment all its external doors are closed following embarkation until any of such doors is open for disembarkation. What are other acts that are prohibited? To assassinate the pilot, member of the crew, or passenger of the aircraft. To explode or attempt to explode any bomb or explosive to destroy the aircraft. To, whenever the crime is accompanied by murder, homicide, serious physical injuries, or rape. It shall be unlawful to ship, load, or carry in any passenger aircraft operating as a public utility within the Philippines an explosive, flammable, corrosive, or poisonous substance or material. Warsaw Convention. The Warsaw Convention has the force and effect of the law in the Philippines, as the Philippines is the signatory and applies to all international transportation of persons, baggage, good in an aircraft. So is the Warsaw Convention constitutional? There is a presumption of constitutionality as it is adopted by the legislative and executive department, which are presumed to have studied it carefully. And this covered it applies to international air carriage. When is it not applicable? If there is willful misconduct on the part of the carrier's employees, the convention does not regulate, much less exempt, carrier from liability for damages for violating the right of its passengers under the contract of carriage. When it contradicts public policy, if the requirements under the convention are not complied with,